SJC-12488, Jaideep S. Chawla v. Massachusetts Appeals Court.
Mr. Chawla, good afternoon.
Good afternoon.
You have 10 minutes, sir.
Thank you. May it please the court, my name is Jaideep Chawla. I'm the relator in a case against two alleged cocaine dealers beginning in June 2014 in Suffolk Superior Court for non-payment of the Massachusetts Controlled Substances Tax. That case was dismissed after a motion was filed by the Attorney General's office and it went up on appeal. There was a panel duly formed, Justices Katzman, Carhart, and Kinder. The case then went to oral argument before those justices. That argument happened in January 2016, proceeded through the summer. In August, the appeals court issued a decision, the same three justices. I proceeded to file a petition for rehearing, raising for the first time what I alleged were improper payments from the U.S. Department of Justice to the Office of the Attorney General through the Equitable Sharing Program. The same panel, with Justice Katzman taking part, ordered the Commonwealth to respond on or about September 12th, 2016. And Justice Katzman, of course, became a federal judge on September 15th, 2016. And on October 6th, a new panel announced that the petition for rehearing was denied. And I am seeking that judgment be vacated for lack of notice of the formation of the new panel. And in addition, that Justice Nyman ought to be recused, both based on the due process clause and based on the reasonable person standard under Commonwealth versus Eddington.
And should be because I think you say he had at one point been an ADA, but wasn't that years ago?
Yes, that was years ago. This whole case is sort of a mystery. The Commonwealth stated that the Commissioner of the Massachusetts Department of Revenue suspended enforcement of the Controlled Substances Tax. I've spent several years trying to find out or to verify that statement. That statement was made in open court, both in the Superior Court and in the Appeals Court. And so I've never found information based off of that. And the reason why Justice Nyman's prior history as an ADA is relevant is this whole case kind of hinges on a case 20 years ago, Commissioner of Revenue versus Mullins. And Justice Nyman was a narcotics prosecutor at that time. And so he should have some sort of knowledge of the circumstances surrounding what happened with the non-enforcement after the Mullins decision. In addition, I think just based on the reasonable person standard, based on the circumstances, of how—
He wasn't the prosecutor in that case, right?
What's that?
He was not the prosecutor in that case. He was just a prosecutor at that time. Is that what you're saying?
Yeah, Justice Nyman has he made no prosecutorial decisions affecting this case. The question is information. Now, to be completely frank, I don't even know whether or not the CST, the Controlled Substances Tax, has been suspended. That's the Commonwealth's representation, and I've spent several years trying to verify that in court. There's another case pending in the Superior Court trying to verify that, so you feel free to ask the Commonwealth, but I'm not even sure if that happened. So I raised that issue based on the Commonwealth's representation. So that is what it is.
Why was your remedy not to seek further appellate review after you were denied relief in the appeals court?
Because I'm entitled under Rule 27 to disposition of my petition for rehearing by the panel or quorum which decided the appeal. And Justice Nyman had no part whatsoever in this appeal. He didn't participate. His name was never announced. The appeals court never even mentioned his name and said he was taking part. I've noticed, by the way, that this court when a justice, didn't partake in, let's say, oral argument, provides notice to the parties that they will, based on the briefs and a recording of the oral argument, take part in the disposition of the case. There was no notice whatsoever, and because of the plain text of the Massachusetts Rules of Appellate Procedure, I've got a statutory entitlement to a certain disposition for my petition for rehearing. So that didn't happen.
So you argue, but the point is, if you're wrong about that, the other side has a chance to say that. And
Say that again?
I said, that's your allegation, that you have this right. But if that doesn't mean it's so. I mean, and that's why the judge asked about further appellate review as being
Sure,
limited.
yeah, and I'll go into further appellate review. So one of the issues with further appellate review is based on it's Rule 27.1, I think it's 27.1E, Justice Nyman would participate in the disposition of a petition for further appellate review.
No, he wouldn't.
He wouldn't.
It's decided by us.
Well, the rule as it's written says that a majority of the justice of the appeals court,
I don't think so.
Not with regard to our
or
decision whether to take further appellate review.
Sorry?
Not with regard to our decision on the SJC, whether to take further appellate review from a decision of the appeals court. That's decided only by the SJC.
Okay, well, even notwithstanding that, the entitlement that I had, the actual petition for rehearing ought to have been disposed of properly before all of the issues on the merits, because there's separate issues on the merits that would have to come up to the SJC. So shouldn't be any commingling of a petition. The petition for rehearing ought to have been properly disposed of, and then a petition for further appellate review could proceed, but those would be on the discrete issues that had actually been reviewed. So again, just speaking out loud, further appellate review, there was no initial appellate review of Justice Nyman's recusal. So let's say I had proceeded to seek the recusal of a superior court judge, yeah, it would have gone to the appeals court through the normal course, and then maybe I could have come to the SJC through further appellate review. There was no initial appellate review of Justice Nyman, the issue of his recusal. And so that never happened. That's patently unfair. And I would just say that, again, the circumstances, I think, need to be taken into account of this case. So there was alleged wrongdoing, and I'm going to dispense with any innuendo, but there was alleged wrongdoing, and the appeals court took a relatively, from my understanding, rare step of requiring the Commonwealth to respond. That doesn't happen all the time, is my understanding, because of the seriousness of the issues, that the Commonwealth's prosecutorial discretion was interfered with by the Department of Justice. Now, if that's true, the Commonwealth should have raised these payments back in the trial court. And so you have to look at, in my opinion, you have to look at the totality of the circumstances here. It's not just that I filed a petition for rehearing and I think that I'm aggrieved. It's that there was alleged wrongdoing at issue in that petition for rehearing. And so the manner in which Justice Nyman all of a sudden, again, without notice, came into this case to decide it is what I object to. And I have really nothing further. I can rest on the briefs. I think I'll just be repeating myself, so I won't take any more time unless the court has further questions.
Okay, in the absence of further questions, thank you. Mr. Walker.
Good morning. Jeff Walker on behalf of the appeals court. The single justice decided this case reasonably and correctly when he found that the appellant's claims were an inappropriate use of this court's extraordinary power of mandamus. He was given more than 5 months to seek further appellate review. All of the issues that he's raising here today could have been raised in that application. And to the extent that he's arguing that he was entitled to notice, as we briefed, that is a incorrect statement of law. The appeals court is allowed to substitute a justice on a panel, and the rules of appellate procedure, Rule 24, provide that can be done upon perusal of the record. The Commonwealth did respond to his petition for rehearing. It was filed, and it was decided on both motions.
There was a disposition with finality that could have been appealed?
I believe it could have been appealed under Rule 27.1, which allows for an application for further appellate review.
That there was a judgment entered?
The judgment had entered prior to this recusal issue.
Right.
But I believe the scope of Rule 27.1, which allows for appeal of anything that's in the public interest or the interest of justice, I mean, based on the types of arguments that the appellant is raising, I think that would fall into that category, both in terms of appealing the actual decision in his appeal and the various procedural events that he took issue with after that decision was rendered.
Okay, and he was given 5 months to do it?
He noticed his appeal, or his intent to seek further appellate review. He was given several extensions, and I think the 5-month period elapsed shortly before he filed the mandamus action. It seems to me a textbook case of trying to substitute mandamus for ordinary appellate review, and we believe the single justice correctly found that the general practice of this court to not allow mandamus to be used as a substitute for further appellate review covers all of the other claims raised in this case.
And I should know, but what is the controlled substances tax?
The controlled substances tax is a law that says those in possession of illegal narcotics are obligated to pay a tax. I think maybe there needs to be an intent to distribute. And essentially in 1999, in the Mullins case, this court ruled that to enact a penalty under that law, because there was also a penalty for not paying the tax, to someone who had already been charged and indicted under the federal criminal drug laws, essentially raised double jeopardy concerns, that this looked like a criminal penalty that was being imposed on someone for the same conduct. And in response to that ruling, the Department of Revenue has not enforced those fees since 1999.
Okay, if there are no further questions, thank you.
Thank you.